Hi, Nader. How are you?
I'm very good. It's good to be back.
Good to see you again. And well, this time you are the award winner of our Wicked Ally Award. Congratulations on that. You received that award last September at our Vail conference. So I wanted to congratulate you for that, first
Well,
of all.
thank you very much for that, and that's a huge honor. I'm still a little bit in shock that you folks decided to give me that tremendous honor, but I will take it.
Well, we're not shocked at all, given all the work that you've been doing and you continue to do and the support that you've been showing for many of our female colleagues. So it's a very well-deserved award. And I'm very happy to have you as a guest again. And today it's actually going to be a very topic-specific interview where we're going to be talking about something that you actually like to argue a lot about and write a lot about, and that's the charter. Just for people who don't know, you've written quite a lot about charter issues. There's an Iman book on search and seizure that anyone can find. It's a really good book, and it's actually one of their bigger books, more voluminous. You also argue quite frequently before the Supreme Court and Ontario Court of Appeal in issues that do have charter arguments. So you are the perfect person to have as a guest here today to talk about some basic charter issues that I think will be very helpful for many new lawyers and even some practicing lawyers who have been practicing for a long time. So we're going to start just from the beginning when it comes to
Sounds
charter,
great.
and that will be disclosure. When it
Okay.
comes to disclosure, Nadir, maybe if you
Yeah.
can tell us what should a lawyer be looking for in the disclosure and what to request and how to request it in charter cases.
So when it comes to disclosure, uh, in some ways there's no magic that distinguishes a case that's charter application heavy from any other ordinary criminal case. Like any case, you need to know the disclosure inside out, and you need to review very carefully whatever the Crown sends your way. Um, so you can't know what it is you need to request if you don't review all the disclosure to know what is missing. And just in terms of the practical side of things, I mean, it will come as no surprise to people who've been practicing criminal law for more than a day that the Crown does not give you everything you're entitled to have on the first go around. That's not necessarily malicious on the part of the Crown. They're relying on the police, the officer in charge to provide them with the relevant disclosure, which they then provide to you. So they mainly act as a conduit, and they won't necessarily go out and inquire with the police if you don't push them and if you don't ask for specific things. That you have to take upon yourself. Yes, McNeil, Stinchcombe, and its progeny requires that the Crown go out and inquire of the relevant police agencies, but they're not going to do that and take those steps unless you put them on notice of certain things you want. Um, and you need to follow up repeatedly with the Crown. Um, some of us are guilty of this, and I will include myself among them, is we send the Crown these long lists of disclosure that we want, but then we don't necessarily track all the time, when the Crown has complied or has not complied with these requests. And so I think, what I've started to do as a matter of best practice is um, when I send out a disclosure request letter, I will have an Excel spreadsheet as well set up with the specific disclosure request in the first column. The first day I requested it, subsequent days I requested it, and the status of the disclosure. Has the Crown complied with that disclosure request? Have they partially complied with it? Have they given a reason for why they haven't? Have they told me it doesn't exist? And then you need to follow up with them. You need to follow up with them diligently. And this is the only way to get the material you actually need. It also helps you protect the record in the event that you're bringing in a Section 11B application. Um, so as a matter of practice, if I don't get the disclosure I am seeking, I will follow up every 2 weeks, and sometimes it'll go 3 weeks in between, but no more than 3 weeks in between disclosure requests. Sometimes I get a nasty email back saying, "Stop emailing us. We have your request." But that's not much of a deterrent. I think it's still good practice to send these frequent reminders. As it relates more specifically to charter cases, I mean, it's difficult to speak in terms of generalities because we're talking about a very diverse array of different rights, and the procedure may be a little bit different um, as it relates. The type of disclosure you're asking for in an abusive process application is very different from the type of disclosure you're going to be asking for in a Garofoli application. But one thing that doesn't change is that you need to know the area of the law, the substantive area of the law, so that you can know what to ask for. You need to know what you have to prove in order to know what is going to be useful to you. And so, I mean, that's a plug in favor of doing as much self-learning and attending as many CPDs as you can. And it's important not just to know the substantive area of law, what the case law says, um, what the courts have been saying about particular charter rights. It's also important to know how the investigative techniques at issue, how they work in practice. So, for example, if we were to take a Garofoli application in a wiretap case, in wiretap cases, each communication, the police use a particular type of software. Usually, it's the JSI software, and that software assigns each communication a session number, and creates a log called a session history, which are created automatically as part of the process at the time of the interception. And the session history is a detailed record concerning an interception, and provides an automatically generated audit trail documenting the interception process, which is really important material to review if you're going to challenge the manner or the implementation of a wiretap authorization. But if you don't know what session histories are, what they do, you don't necessarily know to ask for it in this context. So again, it's knowing and having an understanding both of the law in that particular area, and then also a little bit of a deeper understanding about the investigative techniques that are used and how they operate in practice. And that is, I think, if you have those things, then you have the toolkit to allow you to tailor your disclosure requests accordingly.
And also, maybe if I can add one of I mean, this is more basic than what you said. Obviously, in a charter case, because we're dealing with police officers and state officials, the police notes and investigative actions are very important. And so one of the issues that we usually have is it's very difficult to decipher the handwriting.
Yeah.
And it is important also to be able to read those notes very well and to request typed versions of them. When it's very difficult to read them, because that's going to be the most important thing. It's reading what the police are doing and how they're um, cataloging what they're doing as well. So
Oh
police
yeah.
notes are,
100%, 100%. The police notes, um, it might sound
or lack
basic
of
to,
notes. Yeah.
yeah, or lack of notes.
Yeah.
Sometimes lack of notes is an even bigger gift to the
Yeah.
defense than the existence of actual notes. But you make a really good point, Maya, and look, it can be a slog to try to decipher police notes. There's a part of me that thinks they write badly on purpose.
Mhm.
That
I
may not be true.
agree.
That may not be
I'm,
true. I'm being unfair to the
I
police, but but but
I have
it
that theory too.
if they are indecipherable, then don't kill yourself trying to make sense out of them. Request type notes, and more often than not, you will get them. And actually, the police seem to be gradually switching to different software, and some police officers are logging their notebooks electronically in the first
Mhm.
instance now. It's certainly not uniform, but I think there are some early adapters. So maybe eventually we'll get to a situation where you do get typed notes in the first instance from police officers, and that will also make it much easier for purposes of logging and organizing disclosure in big cases, so that you can do keyword searches and because it's a little bit hard to manage and do keyword searches in big disclosure files if all of the notes are in a handwritten format. But absolutely, if you can't understand the notes, you and your client are entitled to know what are in those police notes. So if they're indecipherable, that's something you need to be adamant about in terms of getting a decipherable set of police notes.
Right. So, okay, so when it comes to disclosure, we've covered here some of the basics, but then there's another important thing that should also be, I think, clear from the beginning of a charter case, and that is the remedies that we're looking for. What is it that we want ultimately when we have a charter case? So, maybe on this point of remedies, if you can tell us a bit, Nader, about the types of remedies that are available in a charter case. Of course, we know the more common ones, but there are
Yeah.
some other ones that are less used, but that we should also keep in mind how to argue for those remedies and cases where a breach is established, but there is no appropriate remedy. What can we do in these types of cases?
So we'll start with I guess what you were referring to as the common types of remedies. All criminal lawyers will be familiar with the Section 24(2). This
Yeah.
is what allows us to get the exclusion of evidence after a charter breach has been established and the court has applied the three-step grant criteria. So I won't spend much more time talking about exclusion of evidence. Um, Section 24(1) is a robust provision of the charter. It provides it empowers a court of competent jurisdiction to fashion a remedy that they consider just in the circumstances. Just in the circumstances is about the broadest possible language you can imagine. And some courts have taken that language to heart, and I'll return to that in a moment. But one of the more common remedies um, under Section 24(1) is the stay of proceedings. Stay of proceedings, it's one of the most drastic charter remedies. It puts a halt on the proceedings. As a result of some Supreme Court of Canada cases in the 1990s, it was determined, and it's never been overruled, that the remedy for a breach of Section 11B of the Charter, the remedy is a stay of proceedings. So that is probably one of the few areas where a stay of proceedings flows almost automatically from a
Mhm.
finding of the charter breach. You get that stay of proceedings where there's been an 11B breach. The stay of proceedings is also available in other circumstances, namely where there has been an abusive process. And as most of your listeners, Maya, will know, it is a fairly high bar to get an abuse of process finding from a court, but it does happen. It certainly does happen. There are two instances where you can get an abuse of process remedy, and the law was re-articulated in a Supreme Court of Canada decision called Babos, BABOS. So the two categories are first, the first branch is what's known as the main category, where the conduct of the state has compromised the fairness of the accused person's trial. So, as a result of something that the state did, either intentionally or negligently, the accused trial has been undermined and they can no longer be said to be getting a fair trial. That's referred to sometimes as the main category. Then there's also what's called the residual category. It may be that even even if you take into account the abuse that has occurred, as improper as it may have been, it's still possible for the accused to get a fair trial. However, that state conduct is so bad that even though there's no threat to trial fairness, that state conduct has undermined the integrity of the judicial process. And that under that residual category, the court still has jurisdiction to stay the proceedings as a result of the abusive process. However, it's important to emphasize that even where an abusive process is made out, it doesn't automatically
Entitled, yeah.
entitle you to a stay of proceedings. You still have, so first you have to make out a an abusive process, and then secondly you have to show that there is no alternative remedy capable of addressing the prejudice, and that can be where the rubber hits the road sometimes. The court might say, well, there's a lesser remedy. We can exclude this evidence, or we could give you an adjournment that would allow you to mitigate the harm. So an abusive process, it's already a high bar, and then to get a stay of proceedings, even where there has been an abusive process, it's a high bar as well. Um, Section 24(1), though, isn't just limited to stays of proceedings. As I mentioned, that language is extremely broad, and some judges have been quite creative
Mhm.
in fashioning remedies, and some counsel have been quite creative in what they are asking for. So, for example, Section 24(1) has been used on occasion to exclude evidence. Okay. So 24(2) is the usual tool to
Yeah.
exclude evidence, but you could have a hypothetical situation where you couldn't meet the grant test for exclusion of evidence, but because of some improper state conduct that has occurred, you have a good argument that nonetheless the evidence should be excluded under Section 24(1). So uh, even in more traditional exclusion of evidence cases, Section 24(1) is something you still ought to turn your mind to. It's not going to be your main argument, but I wouldn't necessarily rule it out altogether, depending on what your facts are. Section 24(1) is also a tool that can allow your client to get charter damages. Okay, and this is something that perhaps
Unusual
is not utilized
in the
enough
criminal
in the criminal
context.
context,
Yeah.
right? Because all of us have spent a lot of time in many cases putting together a charter application, doing the investigation, getting that disclosure, briefing it up, preparing for trial, and then you serve it on the Crown, and then the Crown realizes, oh, they may have a winner, and they pull the case, and the case goes away, and that's a win. That's a win for you. That's a win for your client because that jeopardy um, was likely quite significant. And to have a case go away just at the point of filing the charter application, that's a win. But you don't necessarily, and your client doesn't necessarily just have to take that win and go home. If their rights were violated, then as someone living in this country whose rights were violated, they have a right to a remedy. And if it's a serious enough charter violation, they are entitled. in my view, to seek charter damages. Now, the damage amounts may not be sufficiently high to justify the additional headache of ongoing involvement with the court process, the justice process. And so your advice as counsel might be, hey, look, you have this additional remedy you could pursue, but it may not be worth your while on the facts of this case. But there may be other cases where the harm to the individual was both psychological and physical was quite severe. And I think it's incumbent upon us as counsel to at least advise our clients about that possible remedy.
Well, in a case, let's say, for example, where there is an interaction with the police and the accused gets injured and they have
Yeah,
to go through, I don't know, surgery or a
yeah,
medical treatment. I mean, the least I think that would be fair to our clients is if there was also a charter breach, is that they get paid, compensated
yeah.
for the money that they had to pay for all these injuries and medical treatments, right? Like, I think it's only fair.
I mean, if fairness was the touchstone of our system, then I'd have to agree with you. We know that the system isn't always fair, and in civil proceedings, the loser pays, right? In criminal proceedings, even if our clients are fully vindicated, the Crown doesn't pay unless there was egregious conduct on the other side, or if you can make out a charter violation and make out the test for charter damages. So there is a bit of asymmetry in that system, and I think just to put the point in simpler terms, there is a bit of an unfairness, particularly for someone who should have never been charged in the first place, to have to go through that hassle, that expense, the stress of being put through the process, and then not really have any compensation at the end of the day. But in charter cases, there may be a way to get some compensation, and in the right case, it may be worth their while.
Right. But in cases, Nader, where there is a violation and there
Yeah.
isn't really a very appropriate remedy, what do we do with these cases? Like, let's
Yeah,
say
I
there's
mean,
no statement to exclude, or like there is a breach, but there is, I mean, like we do have these cases where there's clearly
yeah.
something wrong that the police did, but then, I mean, it's not going to serve anything in the traditional charter remedy way. So, but do we just let it go like that?
Yeah, I mean, look, I think it's going to vary on a case by case basis. And we talked about money damages as one possible remedy in that situation. It may be a situation where there is no incriminating evidence that was generated as a result of the charter breach, like the scenario you're talking about, Maya. But but that fact doesn't undo the breach having happened, right?
Mhm.
So there's still been a
Right.
breach and there should be a remedy.
Yes.
There may be situations. So for example, if the case ultimately ends up in a guilty plea or a finding of guilt, the fact that there was a charter breach can and in fact should be taken into account
Mhm.
at the sentencing stage. That has been the law at least since the Supreme Court of Canada's decision in Nassau-Galluac. So, I mean, I would I resist the idea. I think we should be resisting the idea that there could ever be a charter breach without any kind of remedy. It should always be it should always have at least some role to play. I mean,
Right.
it's one thing if the Crown says, okay, there was this charter violation, I'm gonna walk away. But if there's an ongoing prosecution, then the fact that there has been a charter violation that has to affect something, okay? And perhaps it affects the Crown's resolution position, and you can use it in that negotiating process, or perhaps it affects the ultimate disposition and sentencing if there's not a clear sort of traditional Section 24(1) or Section 24(2) remedy.
All right. Now, we did cover Section 24. we're not going to go through all the we're not going to go through the specific sections. We all know what the sections are and what we're talking about. But one section that I do want us to cover, which is always a bit of a more difficult section, which is section 7.
Sure.
Section 7 is maybe not as clear, let's say, as the other sections like section 8, 9, and
Yeah.
10 that we usually use. And so sometimes it's difficult to really understand, what does section 7 really mean?
Yeah.
What are the rights that are protected under section 7, and how to properly argue a section 7 breach?
So we all know the text of Section
Yeah.
7. Everyone has a right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. And so I think most of the jurisprudence and the conceptual heavy lifting is around principles of fundamental justice. Although, there is some interesting case law as to what triggers life, liberty, and security of the person. But for criminal lawyers, that first part is less of an issue because when someone is facing criminal jeopardy, there is always a liberty interest
Yeah.
that has been triggered. So the criminal lawyers don't have to worry so much about the first part of the Section
Mhm.
7 test because you're always going to be there. The civil litigators, they have to first argue that life, liberty, or security of the person has been engaged before they get to the principles of fundamental justice. But we are always engaged in a situation where life, liberty, and security of the person
Yes.
has been triggered. That there's that threat. So the principles of fundamental justice, what those are all of those rights and principles, that panoply of fundamental rights and principles that underpin the right to a fair trial in a constitutional democracy. And to put some more concrete uh, on that concept, uh, some of the principles of fundamental justice are enumerated in sections 8 to 14 of the Charter, right? The Supreme Court of Canada and the BC Motor Vehicles reference when they're explaining what the principles of fundamental justice are. They said it's a broad concept. It's the basic tenets of our legal system. And by the way, the rights articulated in sections 8, 9, 10 through 14 of the Charter, those are examples of principles of fundamental justice. But Section 7 isn't limited to just those. It's broader than that. But those specific enumerations, articulations of Section 7 principles of fundamental justice help inform what other principles of fundamental justice are. And so what Section 7 often does in our system is it helps fill a gap that exists between the enumerated rights and other rights that are necessary to give those enumerated rights actual meaning and value. So, for example, the right to make full answer and defense. It's not specifically articulated in sections 8 through 14, but it's very clearly part and parcel of uh, a right to a fair trial. And many of our other rights that are specifically enumerated in the Charter wouldn't really be meaningful if you didn't have that overarching right to make full answer and defense. And so it's been recognized. And likewise, the pretrial right to silence.
Hmm.
Pretrial right to silence isn't specifically articulated in the
Right.
Charter. The trial right to silence is in there in Section 11 of the Charter. But the Charter doesn't specifically say anything about the pre-trial right to silence. But of course, your right to a trial right to silence and your right to counsel would be rendered illusory and meaningless if you didn't also have a corollary pretrial right to silence. And so the same is true with the right against self-incrimination. You have Section 13 of the Charter, which deals with the right against self-incrimination when you have testified at a previous proceeding under compulsion.
Right.
But the Charter doesn't deal with specifically doesn't enumerate the more general right against self-incrimination, but the Supreme Court has very ably reasoned that a lot of our other rights would not be realizable if we didn't have that corollary right against self-incrimination throughout the entire process. So in many ways, the rights we have in Section 7 are fill serve a gap filling function to fill in the gap in the rest of that charter to ensure that the rights that have been specifically recognized and given constitutional protection that they remain vibrant and meaningful.
And should a Section 7 argument be always made in conjunction with other charter sections, or can you just have a charter argument only based on Section 7?
Oh, no, you can certainly have a charter argument based only on Section 7. It's sometimes there are other provisions of the charter that function in a complementary way
Yes.
with Section 7, but no, it certainly can be the basis for a standalone
Hmm.
charter argument. You know, for example, if you're making an abuse of process argument, um, you would invoke Section 7. You might also invoke Section 11D, but I don't even think that's necessary. And if you're arguing against the right that there's been a breach of the right to silence, you can rely on Section 7 alone. You might say, oftentimes if there's a breach of a right to silence, that happens in conjunction with a
Yes.
violation of the right to counsel.
Yes.
So you would argue that in tandem, but there's certainly no requirement that Section 7 be argued in tandem with something else. It is in many ways the most robust of all of the charter provisions.
All right. Um, now there are also, I mean, as we're talking about how to argue Section 7, but in a more general sense, um, what approach should lawyers take in charter arguments? Because I think what many lawyers tend to do, I mean, I do this also. I mean, I'm not, when I say many lawyers, I mean, I include myself, but
Yeah.
we tend to throw in all the sections of the charter,
Yeah.
and we just try to see like if hopefully one of them will win. So, but what is the best approach when we're making a charter argument? Is it to just try to put everything, just throw all these sections and just hope that one of them will win? Or should we just have it very focused on one or two or just one? Like, what's the best way, strategically speaking?
Yeah, I mean, it usually depends on the facts of your case. I generally am not in favor of a kitchen sink approach. I'm generally in favor of um, keeping it lean and really focusing on your best arguments. You get credibility by focusing on where you're strongest, and you don't lose a whole lot by not including arguments that are probably not going to win anyways. I think it suggests maturity of thought and level of preparation if you are just really focusing on your best arguments. So I think I typically lean on the side of the less is more approach.
Okay. And does that approach also apply when we're talking about having a factum? Because I mean, in
Mm.
OCJ, it's not a requirement, but like, is it a good idea to have a factum for a charter argument and to lay down your argument, lay it out before we go and argue, or should you just rely on the basic, the very simple form one that we have to at least, or the notice of application? Like, what's your approach when it comes to the argument itself? Should it be developed?
Yeah, yeah. So that look, I think there are reasonable people who disagree about the factum and no factum. You are quite right. The OCJ criminal proceedings rules do not require a factum. Even the SCJ rules don't require a factum, although I think most of our experiences will be that that Superior Court judges generally want a factum.
Mhm.
They'll specify that on the JPT form, and you'll have a usually at the JPT you'll have a deadlines for exchange of the factums. Um, my view is generally in favor of a factum in every case, whether it's OCJ, whether it's Superior Court, whether it's a simple argument, whether it's a complicated charter argument. I think that the ability to write a factum is a an advocacy opportunity that we should try to seize, and I think it can only benefit us to have that factum. Oftentimes, because many judges will tell you that they've kind of made up their mind already going into a hearing based on the written materials, and we can't, whether or not you think that's a good thing or a bad thing, that's the reality. And so your best opportunity to persuade the judge to your cause may be through the written materials. Now, I understand that there is a bit of a tension here because sometimes your charter application is going to depend on the success of your cross-examination of police witnesses on the charter of voir dire. And so I know that there is sometimes a concern about being too detailed in your written
Mhm.
materials, lest you tip off the Crown
Right.
and tip off the police officers. So, look, that is a real tension, and that is something you're going to have to think your way through it. And so, when I say I'm generally in favor of a factum, that doesn't mean each and every case I'm going to have a detailed 30-page factum. In some instances, I might have a shorter factum in which I focus on the law because I want to make sure that we're at least on the same page as it relates to the law. But I'm a little bit more bare bones on the facts because I don't want to tip off the police officer at issue or the Crown even on what specifically we're going to try to establish on cross-examination of the officers. That concern is more significant in certain types of charter applications than others. Some applications don't rise and fall on what the cops say on cross-examination, but others do. Others do. A Section 9 arbitrary
Yeah.
detention or racial profiling case, the cross-examination of the officers is going to be critical. And then also on a Garofoli application, the officer's reasons for not including certain things can go to their good faith or bad faith in conducting the investigation and in preparing the ITO. So you don't want a situation where yes, you've written a brilliant factum and you've provided it to the judge and the judge now knows exactly where you're going and what your argument's going to be, but at the same time you will have tipped off the police to your best arguments, and then they can be on guard during cross-examination. So there's that tension there, and but I think the important thing is that you turn your mind to this tension and figure out on the facts of this particular case, are you best served by being detailed in your factum, or are you best served in holding something back? Now, the other thing I will say is that as a matter of practice now, whenever I serve a factum on a charter application, I always request that the Crown not provide any of the charter application materials to the officers involved.
Mhm.
And I ask that they acknowledge in writing that they won't do so. And sometimes they say, no, that's fine. We get that. I agree with you. The officer shouldn't have these materials. Sometimes the Crown ignores that request, and sometimes they say, you know, go pound salt.
Yeah.
I have to prep the officer, so of course I'm going to show them the material. Okay. Now, first scenario is the best one, especially if it's a Crown you trust and they're sincere when they say they're not going to share the charter materials with the officer, because then you got the best of both worlds. You've done a good factum that will educate the judge on the issues and put a persuasive gloss on your position, and the officer isn't going to be tainted by your arguments and fashioning their answers on cross-examination. So that's the best of both worlds scenario. But in scenario two or three, where the Crown ignores your request or says, "I'm gonna, I'm going to uh, show them the materials anyways," you can use the letter you wrote to the Crown on cross-examination. You can put it to the officer. Hey, are you aware that we made this request? And did the Crown give you these materials anyways? Okay. Now, maybe the judge doesn't think there's anything wrong with what the Crown did. Maybe you get a judge who thinks there's something wrong with that. And maybe it has an impact on the Crown sharing the materials, the charter materials, with the officer the next time around. Now, the fact that you can do that isn't necessarily,
Yeah.
you know,
You're not going to
not
win the
foolproof.
case. Yeah.
It's not foolproof,
Yeah.
right? But it's something. It's something in the toolkit that you can potentially use.
Okay. Um, and speaking here of the charter argument, now there is the factum, which is the written aspect of it, but we also still have to argue as well. So there's the oral submissions that we have to make. And so maybe what distinction would you make between what we do about the argument in writing, Nader, and then as opposed to the submissions, the oral submissions that we make when it comes to a charter argument?
Yeah, I mean, look, it's like preparing for any oral argument, be it appeal at the trial level. You don't want to necessarily repeat everything you've said
Right.
in your written argument. Having said that, in some charter cases, if you're in a scenario where you held something back out of your factum because you were worried about giving away too much, by the time you're making oral argument, the evidentiary record will be closed, right? And
Mhm.
now you don't have to worry about letting the cat out of the bag. You can now be thorough because you don't have to worry about the police officer tailoring their evidence. So, usually the factum will be what's extremely thorough, and the oral argument is very targeted and limited. But in a situation where you held something back from your factum,
So that will be
because
the
it's a bit
opportunity.
of a
Yeah.
yeah,
For,
it's a bit of the shape is different.
yeah.
Of the oral argument might be more thorough. And I'll say, I mean, even though this is not necessarily provided for in the rules, sometimes I will provide a supplementary
Factum.
factum
Yeah.
at the time of the oral argument that incorporates the answers from the
Well,
police
so
officers.
because on that, I do have a point because here is also sometimes some of the difficulties we may have with writing a factum before we get into the actual
Sure.
cross-examination and everything. It's because it's anticipatory, where we don't
Yep.
know yet how the evidence is going to play out. I mean, at cross-examination, putting aside the fact that the cops, they they got some help or some prep from the Crown. Sometimes, I mean, the way it will unfold is
Yeah.
some surprises can happen, and that
Yeah,
could
and sometimes it may even be better than what you anticipated.
better or worse, or it could
Yeah.
just change. Like things
Yeah.
could change, and maybe you discover something new, some
Sure.
disclosure sometimes that should have been requested that we didn't know, but the nature of the answers that are coming out in cross-examination will change a little bit. So that's why also the factum, yes, it's helpful because it gives you a general idea of what you're going to be arguing, but you don't really know how things are exactly going to play out during that charter cross-examination of voir dire, and we'll get into the voir dire in a few moments. So that's why also maybe a supplementary factum could help, or that's when maybe the oral submissions will help, or
Yeah. Yeah, I mean, look, sometimes if you try to file something, um, a supplementary factum, the Crown will say, "Oh, well,
yeah,
if they get to file something else, we want time to respond in writing as well." Sure, that might happen. I still think on balance, if you have something more to say and it's substantive and it's significant, and you think you'd be aided by a supplementary factum, try to get one in, even if the Crown gets their right of reply. I think on balance, it's still good for you. And just like, don't call it a factum. Just call
yeah,
it supplementary submissions
submissions,
or aide memoire,
yeah,
to the oral argument, or memorandum of
yeah,
fact and law. Just call it something different. If you can keep it short, all the better. But if you're, at the end of the day, I think judges want us to be helpful to them. And if by providing something in writing that digests the evidence from the prior 2 days and ties it back to the issues, if we're able to do that in a concise written document, I think it's ultimately going to be helpful to them. And I think they're gonna let you do it. Every once in a while, a judge will say, you know, the time for briefing this is over. I'm not going to accept this. The Crown is objecting. So be it. But I think 9 times out of 10, it'll work, and it'll be helpful to your cause.
Do you think that written submissions or arguments are more are better and stronger than oral submissions?
I've had this conversation with judges before, and sometimes, I remember one judge when I was very young. I asked this question of a judge, and it was a Supreme Court judge, and they said that they really know which way they're going to go before oral argument 90% of the time, which is a lot. Other judges have said, they have the oral argument makes a difference only in about, 20 to 30% of cases. The oral
So, but
argument makes
but
a
that's
difference.
in a case where there are some written submissions that are provided. Like at the Supreme Court, you always have to
Sure.
write.
Yeah.
But
So
in a
Supreme Court's
case,
a little bit different. Yeah.
right, because you
Yeah.
have to, like, there's no escaping
Yeah.
that. But in
Yeah.
jurisdictions like OCJ, you don't necessarily have to write. So, but is in where you have the option of you could
Yeah.
write something, or you may just go and make your argument orally. You don't really need to write anything. But do you still think that writing is still more effective? It's a better way, it's more persuasive than oral submissions? Do oral submissions help at all?
So, look, oral submissions certainly can help, and I'm a big believer in oral argument, and I think it can be helpful. But written submissions can oftentimes help more.
Mhm.
And even when it's not required, it's a gift to be able to submit that factum and make your best case in writing. People, judges are human beings like the rest of us, and most of us retain more when we're reading at our own pace than when we are being spoken to and lectured to. That's just how we're wired for
Yeah.
most of us. There are, I think, very few people who are better learners at just listening to a lecture than reading. in terms of what they retain going forward and the ability to be persuaded. So it's not going to be the case that uh, the written material matters more than the oral submissions in every case. But I think you should operate with the presumption that the written material is going to make a difference and operate under the assumption that judges are going to go into a hearing with some preconceived notion of what they're going to do based on the written material. And if that's your presumption, then you should want to be putting your best foot forward.
All
And
right.
that often leads in the direction of filing a factum.
Yeah. Yeah. And it doesn't have to be a very long one. Like you can also
No.
just give just even if it's a summary of your argument and you want to elaborate later on in oral submissions, but still having the outline of the argument in writing, I think.
100%. And you know
Yeah.
what? Like there are the criminal defense bar is extremely collegial. And I have never said no to someone who has emailed me and said, "Hey, do you have a precedent for this type of charter application?" And most criminal defense counsel will be very much of the sharing mindset when particularly younger counsel reach out to them and say, "Hey, do you have any precedents on this?" So if you're not in a medium size or large firm with a precedents database, if you're out on your own, I would urge you if you're preparing, your first Section 8 application or your first Section 9 application, reach out to friends and colleagues and more senior counsel as well, and reach out to them and say, "Hey, do you have a precedent on this?" Because there's no need for us to reinvent the wheel
Yeah.
for each charter application. I mean, every case is different, and you need to tailor your argument to the specifics of your case. But there isn't necessarily the need to reinvent the wheel when it comes to explaining the law in a particular area. So. Look, I get that drafting a factum is laborious and it can, if it's not required, it can be tempting to say, okay,
Well,
I'm not going to do it, but
and
but it's
also,
helpful.
I mean, many, and I agree, but I mean, I think many criminal lawyers, especially trial lawyers, don't like to write. There's a reason why many of them don't go into appellate work. They don't like to do that. It's they don't like to write, and that's why writing a factum may seem scary or just
Yeah.
frustrating for many lawyers. But for those who do like to write, and there are many who enjoy writing, I mean, a factum is a very that's the main type of writing that we do as
Yeah.
criminal defense lawyers. So, Nader, I don't want to take too much of your time, but there were just two more points, if you don't mind, that I wanted us to discuss, and that's the voir dire and whether or not a client should testify or not when it comes to charter issues. So, I don't know. I can leave it up to you if you want to cover one or both of these points very briefly.
Yeah. So, the charter voir dire, this is the evidentiary hearing
Mhm.
for the charter application, and it includes an evidentiary portion and it includes the oral argument. Um, there isn't always live evidence in a charter application. Sometimes with the consent of the Crown, you can argue the charter application on the basis of affidavit evidence or an agreed statement of facts. Sometimes in the Garofoli context, you can attach to an affidavit the disclosure material that you are going to be relying on for purposes of amplification, and you don't need to have a full-blown evidentiary hearing with live witnesses called. But if we were to focus on the the charter voir dires where there are live witnesses being called and where live witness evidence is important, there's a bit of flexibility in how those applications unfold. Um, you can have the evidentiary hearing and the voir dire pre-trial. That's what we might call the traditional model. You have your application, your charter application to exclude evidence. There's a ruling on that, and then subsequent to that ruling, you proceed to the trial with or without that evidence that was impugned on the charter application. There's also discretion to proceed by way of a blended voir dire,
Mhm.
and and that happens in judge alone trials, where the judge is going to hear all of the evidence anyway. It sometimes makes sense to have a blended voir dire and trial, meaning that the evidence that's going to be relevant to the charter application and the trial evidence are heard at the same time. And that certainly makes sense. It makes sense to do that in certain types of cases where the charter evidence and the witnesses who are relevant to the charter application, where those same witnesses are the Crown's main witnesses on the trial proper. And so that there's a significant amount of overlap
Mhm.
between the anticipated charter application evidence and the anticipated trial evidence. In that situation, it does oftentimes make a whole lot of sense to proceed in this blended manner, and then at the end of the trial judge rules on the charter application and on the merits of the trial proper at the same time. So, for example, oftentimes in an impaired case where Section 8 or Section 9 are at issue, the officers with the evidence that the Crown needs to prove its case will also be the officers with the evidence that the defense needs to make out their arbitrary detention argument, or even in a possession case, a
Mhm.
gun possession case, or a drug possession case. Oftentimes, the evidence relevant to the charter breach is overlaps very much with the evidence that the Crown is going to try to use to make out its case on a beyond reasonable doubt standard. Other types of charter applications, it doesn't necessarily make sense to proceed in that blended manner. A Garofoli application, for example, where you're challenging the issuance of the warrant, those officers may not be relevant at all for the trial proper, but
Yeah.
they're the affiants or sub-affiants for the application, and then the synergies and the efficiencies of proceeding in a blended manner wouldn't necessarily make a lot of sense. Um, Sometimes it's a grayer area where there's some overlap, but not perfect overlap. It's not as extreme as the examples I gave. It's somewhere in the middle. And in those situations, I think the judge is going to be reluctant to proceed in a blended manner without buy-in from the parties, particularly the defense. And and in those situations, I think you have to turn your mind to whether or not there is going to be a tactical advantage or a tactical disadvantage to proceeding in a blended manner. Um, Proceeding in a blended manner can sometimes have very clear benefits to the defense, I think, depending on the facts of the case and what's at issue. Um, because if you're proceeding as a pretrial application and it's not blended, it's on you to prove the charter application. So the police officers are your witnesses. Yes, you're going to get leave to cross-examine them, but they're still your witnesses, and they're going to be on guard because they know it's a cross-examination. And so they know that you're trying to extract concessions that you will later use to argue that what they did is wrong. Whereas in a blended voir dire, oftentimes it will be the Crown calling the cops first, and so you'll get to hear them in examination in chief. And it may be that unwittingly they make admissions, not knowing that they are admissions in examination in chief because they're not on guard yet. And so you may want to turn your mind to whether yours is a case where there's a clear tactical advantage to the Crown going first and examining the police officer before you then cross-examine them to lay a further foundation for your charter application.
All right. And what about then the clients and their evidence?
So I like to avoid having my client
Mhm.
testify in charter application. Sometimes it's unavoidable.
Yeah.
Unavoidable. Um, I like to figure out if there's a way to get that evidence uh, before the court through means other than my own client.
Well, for example, let's say with the detention, arbitrary detention, there's the psychological component as well. So,
Yeah.
in a way, I mean, who's going to give that evidence if it's not your client? So,
No, you're right. Yeah, that like I said, sometimes it's unavoidable.
yeah.
Sometimes it's unavoidable. And sometimes you got to make a decision, right? Like it's not it's never ideal to have your client ha testify before the trial, um, because then there's potentially material that they've now spoken. Um,
Unless
but
it's
on the other
blended,
hand,
right?
unless it's blended. I
Yeah.
mean, that's another thing that goes to
Yeah.
the blended nature of
Yeah.
it, right? If it's blended, this is less of a concern. But
Yeah.
if it's happening in the
The
pretrial
pre-trial. Yeah.
context, then this is an issue you have to turn your mind to. But maybe you also say, well, look, yeah, it's not ideal to have my client testify before the trial, but this is really where the battle needs to be won. If
Hmm.
this evidence goes in, he's probably cooked
Yeah.
on the merits. My best shot at an acquittal is getting the exclusion of this gun, so it makes sense for him to testify on this voir dire. And I understand the pros and cons, and I'm making an informed decision. I'm giving my client informed advice onto, what the advantages of doing so outweigh the disadvantages in this case. Um, but even in situations where you don't need the client to testify, the client can be of critical importance in equipping you with the facts to make your charter argument, particularly if it's a charter argument based on police misconduct as it relates to them or their property. I'll give an example. Let's say we have a situation where it's, a drug case, and let's say the there was an amount of cash that was found. And let's say the police report it as being $10,000 in the disclosure. Well, only the client can tell us that, it wasn't $10,000, it was actually $20,000, and they've pocketed the
Hmm.
other $10,000, right? You're not going to know that
Yeah.
without your client telling you. Um, and well, how are you going to prove that? Well, sometimes when they're taking pictures of the bundles of cash they find, they take photographs before they count it, and sometimes those photographs can undermine, for example, the tally later on. But again, if your client uh, reviews the disclosure as they should, they might be able to tell you things like that. Like,
Yeah.
hey, look, that's the stack as it was when it was found, but that was way more than $10,000. It was $20,000. You're not going to know any of these things without the benefit of their input. So I guess the upshot here is, even if this is a situation where you don't need your client to testify, they may be the ones in possession of critical knowledge that you want to deploy through cross-examination of the police officers, and they may be the only ones who have that. So they are an important partner with you when you craft your charter arguments, even if they're not going to be a testifying witness.
All right. So, Nader, I want to thank you so much for this Q&A on the charter. This was really very helpful, and I'm sure many of our viewers and listeners are going to find this very beneficial to them. It's a good refresher for those who know most of that, but there's also a lot of things here to learn from. And I mean, we're not going to give more details for now, but we'll be hearing more from you about charter. We'll have more work for WiCCD about charter issues that's in the making right now. But thank you so much for this wonderful Q&A. I learned a lot, so I'm sure that a lot of people, especially the newer lawyers, will also learn a lot from the tips. And it's always nice to hear from you. And again, congratulations on your award. That's not your only award. You also received others before that, but it's nice that your collection is getting bigger and bigger. Congratulations.
Thanks, Maya, and it's always a pleasure joining you here on these Wicked podcasts. You folks do a great job, and it's a privilege to be a part of it.
Thank you so much, Nadir.